Mr. Gray, where are you currently employed?
With the Rhode Island Department of Environmental Management.
And how long have you been employed with DEM?
Just over 32 years.
And what is your current position?
I am the Deputy Director for Environmental Protection.
And how long have you held that position in DEM?
It was previously reclassified, but previous to that I was Associate Director for Environmental Protection, and that's been approximately 6 years.
And for the purpose of this project, have you been delegated the authority of the Director of DEM?
Yes, I have.
Are you aware that the EFSB requested DEM to submit an advisory opinion in this docket?
Yes, I am.
And did you contribute to the drafting of any portion of DEM's advisory opinion and supplemental advisory opinion?
Yes, I did.
Specifically, the questions posed to DEM were, 1, whether the facility will present an unacceptable harm to the environment, and 2, identify and characterize the scope of the harm to the environment that this project would cause, and if it determines such harm to be unacceptable, to provide a detailed explanation supporting that conclusion. Did you contribute to those questions?
Yes, I did.
In preparation for your testimony today, did you review DEM's advisory and supplemental advisory opinions?
Yes.
And regarding those 2 questions, has your opinions changed from what is in the DEM advisory opinion?
No.
I now turn to the witness for examination on limited questions in DEM's advisory opinion regarding 1, whether the facility will present an unacceptable harm to the environment, and 2, identify and characterize the scope of the harm to the environment this project would cause, and if it determines such harm to be unacceptable, to provide a detailed explanation supporting that conclusion.
CLF has no questions for this witness.
OER has no questions.
The town has a few. Good afternoon, Mr. Gray.
Good afternoon.
We've met before, I believe.
Yes, we have.
My name is Mike McElroy. I'm the attorney for the town of Borough. As I understand it, the sections that you prepared are certainly that you were shown as the respondent for. There's one section in the original advisory opinion and one section in the supplemental. Is that fair, or have I missed one?
No, I think that's true.
Right. As I look at it in the original, it addresses the issue of whether the facility will present an unacceptable harm to the environment on pages 29 through 30. And then it's the supplemental, it addresses it on pages 13 through 15. Is that fair?
Yes.
All right. On the supplemental 13 through 15. So let's start with the original first on page 29. And at the top of the page it states that DEM is charged with determining whether projects and activities present an acceptable harm to the environment through various permits, correct?
That's true.
All right. And it goes on to say, of course, permits, licenses, and reviews authorized under the Rhode Island general laws and the associated rules and regulations promulgated thereunder, correct?
Yes.
So what you're looking at in terms of the permit applications is the harm that is under your jurisdiction by law in that particular subject area, whether it be wetlands with Mr. Horbert or air with your air emissions people, etc., correct?
That's correct, yes.
You understand, though, that this board is required by the Energy Facility Siting Act to look at whether or not there would be any unacceptable harm to the environment at a complete overview level. Do you understand what I mean? In other words, all unacceptable harms, not specific ones that are subject to permits.
No, I understand the distinction.
Object to a legal conclusion.
Overruled. So page 29 goes on to say with the second sentence that projects and activities determined to be compliant with the thresholds and standards set for acceptability in those various rules and regulations in the context of harm to the environment are approved often through the issuance of permits, correct?
That's what it says, yes.
Right. And once again, the context there is the context of each individual permit and the subject of those permits, correct?
Yes.
It goes on to say, conversely, projects and activities that have an unacceptable level of harm to the environment either result in denial of permits and approvals for the proposed project or activity, or enforcement actions to stop and mitigate the harm for conditions not considered under an application before DEM, correct?
That's what it says, yes.
And again, we're talking about the areas that are the subject of each of these individual permits, correct?
Yes.
So then going over to the next page, page 30, at the top, it says the judgment as to whether the facility as a whole will present an unacceptable harm to the environment will depend on the analysis and decision on each and every permit application required under these laws and regulations. Failure to receive any, and the word any is all caps, of these required permits would represent a determination by DEM that the proposed facility presents an unacceptable harm to the environment. And that's correct, isn't it?
Yes.
So, on the one hand, within each of the individual permitting areas within DEM's jurisdiction, if any of the required permits are not obtained, then by definition, the harm would be unacceptable, correct?
That's correct, yes.
On the other hand, even if they got all the permits from DEM, that's merely a statement that those particular areas dealt with in the permits are acceptable, correct?
That would be the limit of our jurisdiction, yes.
Yes, okay. So let's now move on to the supplemental advisory on page 29. I'm sorry, I apologize. Thank you, Ms. Noonan. I'll start on page 13 of the supplemental. And here again, this is the supplemental request from this board, and we're addressing the same issue, correct?
Yes.
And you start out by pointing out that you've combined the two advisory opinions that were requested because they both essentially ask the same question, and you quote from the original that we've just discussed, correct?
Yes, that's true.
And then the next paragraph is essentially a repeat of what we already just discussed in the original, correct?
Essentially, yes.
Then you go on, and the new information you have here is you're listing the 6 programs under which permits need to be obtained as you currently understand it, correct?
Yes. At the time of the advisory opinion, that's what we understood, yes.
Did you qualify that because there's others? You said at the time of the advisory opinion, has that changed?
No, the only thing that's changed in the bullet list on page 13 is at the time we weren't clear as to whether management of stormwater associated with a specific industrial activity required that multi-sector general permit that Mr. Horvath talked about this morning. Now we're pretty sure it's not required for this particular industrial activity.
Now, if you're looking at page 14, please, in the final paragraph, in the third line, it says, while final decisions have not yet been rendered, review processes have not yet been completed, including public notice and comment, and the applicant must still satisfy its regulatory burden of responding to any comments and deficiencies that may be identified on those applications. Based on the information currently available to DEM, it appears that it is possible for the applicant to meet its regulatory burden in each of these programs. So I want to break that down just a little bit. This opinion was written some time ago, 2017, correct?
Yes.
Has the situation changed? Is it still true that final decisions have not yet been rendered?
That's true. They have not yet been rendered.
Is it still true that the review processes have not yet been completed, including public notice and comment?
Yes.
Is it still true that it's up to the applicant to satisfy its regulatory burden of responding to any comments and deficiencies?
Yes, it is.
Now, what you're saying here when you say that based on information currently available, it appears that it's possible for the applicant to meet its regulatory burden. That is what it says. It says that it's possible. You're certainly not saying in that sentence that you have evidence that they in fact have met their burden, correct?
That is correct, yes.
Then you go on to explain at the top of page 15 that, to be clear, this in no way is meant to prejudge the outcome of the ongoing permitting processes. And there you're referring to the permitting processes at DEM, correct?
Yes.
You're not referring to the permitting process of this board, correct?
No. That is correct. I am not referring to this permitting process.
But rather to indicate this, that if, upon the completion of the regulatory processes, the requisite environmental permits are issued, it is a formal declaration that the proposed facility has met the standards and criteria for acceptable harm to the environment as established in state and federal laws and regulations, correct?
Yes.
All right. And again, just to re-emphasize, that declaration that that standard has been met would be specific to the particular requirements of that particular permit, correct?
Yes.
You're not saying to this board that if we issue these permits, you're required to make a finding that there is no unacceptable harm to the environment, correct? You're not saying that to this board, are you?
Objection. Calls for legal conclusion.
Overruled.
No, we are not saying that.
And you're expressing no opinion with regard to whether there is unacceptable harm to the environment as that standard is set forth in the Energy Facility Siting Act, are you?
Sorry, same objection for the record.
Overruled.
We are not saying that, no.
Thank you. The final paragraph, I'd like to walk you through just a little bit. It talks about, in addition to the impacts outlined above that are clearly regulated by DEM, the facility will also impact the environment in other ways as a result of construction and operation. Construction of the facility will require substantial clearing of upland areas. Upland areas not within DEM's regulatory jurisdiction for the most part, is that fair to say?
Yes, that's fair to say. That's outside our jurisdiction.
In both its advisory opinion and this supplemental advisory opinion, DEM has expressed concerns over such clearing, including impacts on upland ecosystems and habitat, as well as conserved and recreational lands, which are highly valued in this area of Rhode Island. Is it fair to say DEM still has those concerns?
Yes.
Goes on to say, unlike proposed impacts to wetland ecosystems, proposed alterations of upland areas are not subject to similar regulation, and no standards for acceptable impacts are established in state or federal environmental law. Without such standards, DEM is unable to render an opinion on whether those proposed impacts are acceptable or not. DEM still feels exactly the same way?
Yes, we do.
The final sentence is, however, DEM strongly urges the EFSB to consider the foundation of the wetlands regulatory context when evaluating this area. Can I assume this area means the upland area? Or the impacts that are outside the jurisdiction of DEM?
Yes, that's correct.
That such impacts must be avoided and minimized to the maximum extent practicable through specific conditions and requirements if the facility is ultimately approved. And does DEM still feel the same way?
Yes.
Let me ask you a more specific question. There was a witness for the town of Barville, Mr. Anthony Zemba, who suggested to the board that in terms of evaluating the functions and values of the biodiversity in the upland areas, that this board should take its cue from the functions and values analysis that is set forth in the wetlands area. Do you understand the functions and values reference?
I do, in the wetlands context, yes.
Do you think that would be a recommendation to this board that you would think would provide some guidance to this board for how it evaluates the upland areas?
I think it would be good guidance, yes.
That's all I have. Thank you very much.
Good afternoon, Mr. Gray.
Good afternoon.
My name is Elizabeth Noonan. I represent Energy. Thank you for coming today.
In the two opinions that were rendered, starting first with the original advisory opinion, if we can turn to page 30 of that. At the time this was filed with the EFSB in September of 2016, there had only been certain permits filed with DEM at that point, correct?
Yes, that's correct.
So I'll start reading that second paragraph, which starts, currently the application for an air pollution control permit is under review by DEM. Is it still under review by DEM?
It is.
And that application was filed, I believe it was in June 26th of 2015, and it's still under review.
Yes, it is. I believe that timing is right, yeah.
Subject to check. At this time, are you aware that there are no outstanding matters that have been related to Invenergy on that air permit?
Yes, that's true. The last issues were identified to Invenergy. The consultants responded to those, and they're currently in our office being reviewed.
And those responses were to a preliminary draft permit, correct?
Yes, that's correct.
Do you have any idea of when the draft permit will be ready?
Yes, we're anticipating or targeting a time period between April 15th and May 1st for completion of that draft permit and the public notice package that goes with it.
So at this time, the air application is considered complete from DEM's perspective as to what it requires from the applicant?
Yes,
And then just subject to that, it's going to go out to your internal review, then it will go out for public notice sometime in May.
right. That's the target right now.
So when you say it's complete, it's complete except for the additional internal review that's required?
That's correct, yes.
And how long after the public notice period closes, typically before there would be a final permit?
There's a 45-day public notice period, and we're anticipating that there'll be a public hearing during that period of time. Once the public notice period closes, there's a 90-day time for us to respond to any comments that we receive during that notice or at the hearing, and then to finalize a decision on the permit application.
The next sentence, just for completion, anything else on the air permit? I have no more questions. Move on. The second sentence of the second paragraph on page 30 says the source of cooling water for this facility is currently unknown. Again, this was back in 2016. You are aware that Invenergy has proposed to truck water to the site, correct?
Yes, I am. Thank you.
And that doesn't require any permitting from DEM?
It does not, no.
And I believe in their supplemental advisory, DEM essentially said, because it's not within our jurisdiction, we have no comment on it. So,
Yes, I believe so.
I am paraphrasing, but. And then as to the final comment in the original advisory opinion, it says, based on these current conditions, DEM cannot yet render an opinion as to whether the facility presents an unacceptable harm to the environment. That was correct as of 2016, right?
Yes, it was.
And that was in direct response to this board's query to you, RIDEM, whether the facility will present an unacceptable harm to the environment, correct?
Yes,
And that was what DEM was responding to.
yes.
I'd like to go now to the supplemental advisory opinion. Pages 13 to 15. And Mr. McElroy went through most of that, but again, we're starting with the first question at the top of the page, whether the facility will present an unacceptable harm to the environment. This is the same question that was posed and answered in the original opinion, correct?
Yes, it is.
And looking at pages, I guess 13, starting with 13, at the bottom of the second paragraph, where it says, in those laws and regulations, let me back it up. It said sentence before. Specific to the proposed project area, there are 6 impacts identified that are subject to federal and state environmental laws and regulations. You see that, Mr. Gray?
I do, yes.
At this point, are you saying that you believe it's only 5 due to the industrial RIPD's permit? Or the multi-source permit?
Well, since this advisory opinion was issued, the discharge of wastewater has been clarified. So, yes, I think the management of stormwater associated with this specific industrial activity is not applicable anymore.
And that's the 4th bullet at the bottom of page 13, correct?
Yes.
Going on the text in page 13, following what I just read, it says, in those laws and regulations, standards are established that govern how large of environmental impact is acceptable. You see that?
I do, yes.
So the fundamental concept is that because people are requesting permission from DEM under this regulatory scheme, that there is going to be some sort of environmental impact, correct?
Yes, that's the basic assumption on most permitting programs, right?
And so whether it's, you know, a small pad site for a McDonald's or it's an energy power plant, it's people coming to you for review under these regulations where environmental impacts may occur.
Yes, that's true.
And then the job of your permitting staffs is to determine whether or not the alterations that are proposed fall within acceptable levels of the regulatory scheme, correct?
Yes.
At pages 14 and 15, you opine on, I guess, 2 areas. One is essentially the ones that are within DEM's jurisdiction, those 5 programs that we've identified on page 13. And then at the end on page 15, you go in to talk about areas that are outside DEM's, I guess, regulatory jurisdiction. Is that fair?
Yes.
So, in looking again at page, I'm going to go to page 14, the bottom of that first paragraph, the last 2 sentences. If DEM finds that the applicant has complied with the requirements of the applicable regulations, a permit will be issued for the proposed activity. And that states what your regulatory and permitting departments do, correct?
Pretty much, yes.
Okay. Next sentence, the issuance of a permit indicates that DEM has determined that the nature and scope of the proposed activities are within standards for acceptable environmental impact established by the state and federal laws and regulation. That is DEM's charge, correct?
Yes.
And then finally, going down to page 15, still in this area. We haven't been here all this time, but we've read this a lot of times. I've read it a lot of times. Start at the top, where you mentioned that to be clear, this in no way is meant to prejudge the outcome of an ongoing permitting process, but rather to indicate that if upon the completion of the regulatory processes, the requisite environmental permits are issued, it is a formal declaration that the proposed facility has met the standards and criteria for acceptable harm to the environment as established in state and federal regulations. Did I read that correctly, Mr. Gray?
Yes, you did.
And is that still your opinion as you sit here today?
It is.
Going down now to the last paragraph in the supplemental advisory opinion on page 15, this is where you discuss areas that are outside your jurisdiction. Is that fair?
Yes.
And these are the areas that Mr. Ozenkowski will be probably testifying to on Tuesday morning?
Yes, he will.
And in that, at the bottom, and Mr. McElroy asked you about this, the last sentence says, however, DEM strongly urges the EFSB to consider the foundation of the wetlands regulatory construct when evaluating this area, that such impacts must be avoided and minimized to the maximum extent practicable through specific conditions and requirements if the facility is ultimately approved. That is still a DEM's position today.
It is, yes.
So avoided and minimized to the maximum extent practicable should be, I guess, the focus for our engineers to work on as they're preparing their plans to present to this board.
That is our recommendation, yes.
Thank you, Mr. President.
More questions for this one?
I have a couple. So on the permit status, I don't know if we asked Mr. Horvath this exactly, but it sounded like the air permit final decision would be approximately end of the summer. And could we go back to page 13? Can you just run through what you think the timing of the status of these permits will be to the extent that you can? Kind of the status of each?
Sure. So if everything plays out as anticipated, we'll be issuing a final decision on the air pollution control permit the late part of September, the early part of October. That's the timeline that would play out. The alteration permit for wetlands, which will also include the construction general permit review and permit, is still pending a resubmission, the way I understand it. Once we get the resubmission, then that will be reviewed, and if complete, it will go out to public notice over the summer. And likely a decision would be in the same time frame as the air pollution control permit. The discharge of sanitary wastewater was reviewed through a plan submitted to the department under our on-site wastewater treatment system program. That will be relayed to the EFSB because it's one of the permits that is not preempted by the statute. So that would fall under whatever decision the board would make. And from what we understand, the disposal of any industrial wastewater is now being trucked off-site, so there's no permit required for that.
And you skipped the stormwater during construction. The RIPTES permit is also in DEM's purview, and I think Mr. Horvath spoke to that. Will that be wrapped in with the wetlands permit timing?
Yes, it will. It's going to be the same permit, same application, concurrently reviewed.
Also, just turning to page 15, and I don't know if the answer to this is going to be talk to Mr. Osikowski. But the way I read that last paragraph, and I just wanted to ask you, I'm sure you've written this language very precisely, so maybe asking you to expound upon it is not going to bring us any new information. But essentially, our standard is whether the facility will not cause unacceptable environmental harm. And you've laid out that if it meets the permits, then in those areas, that's essentially a finding of acceptable harm to the environment. And then this paragraph talks about impacts beyond the permitting authority of DEM. And basically, and it says there's no standards for acceptable impacts, and then asks us to take a look at the avoid, minimize, mitigate construct for wetlands, and then you further stated today that looking at the functions and values of uplands would be one way to further parse what you're saying and have the board make some decisions. So I just wanted to ask if you to expound, if you could. I feel like what you're saying in that paragraph is when we're looking to DEM for advice on whether the impacts would be acceptable, that you're throwing it back in our court or to Mr. Osikowski. And just wondering if you have anything further to add about these impacts that are outside of the regulatory programs that are being flagged in this supplemental as areas of concern.
I think if I can add anything, it's that when Mr. Osikowski testifies, he's going to talk about concerns related to those upland areas. like you said, those upland areas are outside of our legal jurisdiction to permit or make decisions on, but there still may be environmental impacts in those areas that are within the board's purview to minimize. And yes, to a certain degree, we are throwing it back on the board in the context of all the testimony that's been offered to try and still minimize those impacts as much as possible if there is a positive decision on the application that comes out of this process in the end.
Okay, thank you.
Additional questions for this witness?
Could I just,
Sure.
Director Coit mentioned avoid, minimize, and mitigate. We've talked about that a lot around here. So aside from the, avoiding and minimizing, in terms of any impacts to the uplands, could mitigation also assist in reducing impacts?
Obviously, that would be up to the board, but yes, it could be part of the equation.
Thank you.
Could I ask one final question? Would you agree that one way to avoid the impacts would be not to permit the facility?
I suppose, yes, that is one way to avoid impacts from construction. An operation of a facility is not to build it.
Thank you.
Lawyers can't stop. And if you did that, your whole permitting staff would lose their jobs, right?
No, believe it or not, there are other applications before us that will keep them plenty busy.
But if a no-build, you exist to provide people with guidance and permitting on projects. If no projects exist, you guys don't have any work to do.
Well, I object. Way beyond the scope of this proceeding.
You open the door.
I wasn't talking about all other projects that are within DEM's jurisdiction.
I think you do more than permit projects, is that right, Mr. Gray?
Yes, that is true. We have, we do a
And
lot of
I'm sure
compliance, a
Ms.
lot of
Newt-
inspection.
I'm sure Ms. Noonan does not mean to imply that DEM is under some instruction to make sure that all permits are granted.
Thank you.
Any further questions? Thank you very much.
Thank you.